It is my great pleasure to introduce the Executive Director of the ACLU of Northern California and the San Francisco office, Abdi Soltani.
I've been the Executive Director at the ACLU of Northern California since 2009. I've been a member for about 10 years before that. The year that I came onto the staff was, we're in the middle of this giant economic collapse. It's the first full year of Barack Obama as president. A lot going on in the world. And there was a case that was in the United States Supreme Court that I didn't really focus on. It wasn't a big thing yet, and that case was called Citizens United. In 2009, the case that went to the United States Supreme Court was of a nonprofit corporation, Citizens United, a 501c4 corporation, ideological, not different in form or function than the ACLU itself. A group of people come together, they have a point of view, their point of view might be different than ours, but in basic form, it's not different than the Sierra Club or NAACP or ACLU or any of the groups that people in this room might support. That group wanted to make a film about a candidate for president named Hillary Clinton. And they wanted to distribute that film to be seen by people throughout the United States because they had serious concerns about Hillary Clinton and her background. So they made a film, a documentary, and they wanted that documentary distributed through pay-per-view. The Federal Elections Commission told this nonprofit corporation no. As a nonprofit corporation, you do not have the right to broadcast your documentary criticizing a public official for the world to hear your point of view. And so they sued. And that was the case that went before the Supreme Court. As I've described it now, you have heard this case presented differently than what we hear about in the news. Most of us don't remember that it was a nonprofit corporation that went before the Supreme Court. Most don't remember that it was for a documentary that they went to the Supreme Court, and that they wanted it broadcast over pay-per-view television that they went to the Supreme Court. And in all of those ways, it truly wouldn't be different than if the Sierra Club had wanted to make a documentary criticizing the environmental record of George Bush, or of Donald Trump, or of some other person, and had gone before the Supreme Court. So we didn't really pay that much attention to this case because it looked like any number of cases that's dealing at the edges of campaign regulation and campaign finance. The ACLU filed an amicus brief on the side of this nonprofit corporation that wanted to make a documentary criticizing a powerful figure in our public and government. And it's not surprising, I'm sure, that the ACLU would have done that. This case went before the United States Supreme Court in 2009. When it was argued before the court, it was this narrow issue that was before the court. And the Supreme Court was ready to issue a big decision on questions that were never presented to the court in the case that was brought to them by this nonprofit corporation. 5 votes were ready to cast aside all restrictions on political spending by not just this ideological nonprofit corporation, but by all corporations, including for-profit corporations. Justice Stevens was ready to write a scathing dissent. And when those 5 saw the dissent that he was ready to write, that they were about to decide a case not on the question that was brought before the court, and not on the matter that was argued before the court, but on a question much wider, they would be going far beyond the normal practice of the Supreme Court, which is to deal with the issue that's at hand. And so Justice Roberts, who's a learned and wise justice in his own way, he slowed things down. And he asked for this case to be re-argued on the wider question of whether all corporations, nonprofit and for-profit alike, should face these kinds of restrictions on spending during political campaigns. That's what went to the Supreme Court the next year, 2010. And in 2010, the Supreme Court came back with the decision that they were ready to give a year before, but now they asked everyone to brief the papers differently on the wider question, and then they came out with the same decision, but saving face. And that decision in 2010 made a big change to the United States approach to campaign finance. And what it said was that for-profit corporations and labor unions are now permitted to spend unlimited money in independent expenditures for and against candidates. The Supreme Court did not allow corporations to make direct contributions to the committees of candidates, but they said that it is okay for a corporation to spend its money however it wants to speak for or against the candidate, as long as they don't make it a contribution to the candidate. Y'all following me? Yeah. Okay. So that's 2010. Now, this is a big decision, and it's one that's galvanized a lot of public attention. For the last 6 years, when I've been invited by ACLU chapters like this today, or when I've been invited to speak in public, I talk about a lot of ACLU issues. I'll talk about Andy Lopez and the many other innocent people of all ages, especially black and brown, who've been shot by police. I talk about the raids by immigration enforcement that leads to mass deportations without due process. I've talked about Edward Snowden and the mass warrantless surveillance that's done to all people in this country. I've talked about protecting abortion rights and reproductive rights in the face of laws throughout this country that are seeking to restrict access to women's basic health care. I've talked about equality for lesbian and gay couples and the path over these few years from Proposition 8, when we lost, all the way to our victories in the United States Supreme Court. I've talked about each and every one of issues, and then we've tended to open it to question and answer. And no matter what other issue I've been there to talk about, no matter what other issue is grabbing the headlines in a given day, a given week, or a given month, it's either the first, second, or third question a person in a room like this will stand up and ask, Abdi, what can we do about Citizens United? And if it's not that question that's asked, it's its corollary. Abdi, why did the ACLU take the position that it did in Citizens United? For about literally 3 years, I gave a fairly standard answer that began with the story of the nonprofit corporation and their documentary about Hillary. And that was enough for this room full of angry people to set their pitchforks aside. Because they would understand, well, why did the ACLU get involved in the initial matter the way they did? And then I would go back to the other issues that I was there to talk about. But increasingly, I became dissatisfied with my answer. And I began reading a little bit more and realizing that the amount of my answer wasn't enough. And it's not just enough to explain why did the Supreme Court do what it did, or why did the ACLU take the position that it did, but that we have some responsibility to figure out, well, what is the answer? What is the path forward given where we are? So that's my setup and my introduction. Over the last 3 years, and especially in the last 7 months, I can confess to you all, and my mother is here in the front row, I've read more books than I have since high school. I've gone back and read the Federalist Papers. I've gone back and read the Declaration of Independence and the Constitution. I've gone back and read Thomas Paine's Common Sense. I've gone back to understand, what was it that these revolutionaries were thinking about? And what was it that they were setting out to do with the Constitution? But we also know that the Constitution that was created, it treated black people as 3/5 of a person for the purpose of counting slaves, but denied basic, fundamental rights while upholding slavery. It denied half the population, women, the basic rights of citizenship. So I'm not terribly satisfied to just go back to what the founders intended, because I don't think their intentions are adequate for what we need to do today. So I've gone back and read, how did we get into the Civil War? How did we get out of the Civil War? For a period of 30, 40 years, we had Reconstruction before the Union soldiers cleared the South and Jim Crow set in once again. So these are the things that I've been looking at for how did we get here to this modern system of campaign finance reform? And where does this fit in the question of the history of this country? So with that, I want to just basically begin to share my thinking. So the question I want to first get at is, how did we get here with our system of campaign finance? Second is, why is this so difficult as a legal and constitutional question? And then third, where can we go forward given this history and these complexities? So there's not that much that you can really discern about campaign finance up until about 1900. Elections were so different. The electorate was so small based on categorical exclusions of most people, based on race, gender, and lacking property, that there's not that much that one can really draw from how elections were run that tells us much that's useful now. Beginning in about 1900s, corporations began to gain a level of power and scale. The railroad corporations, the coal corporations, the insurance companies, the financial institutions, that the public really became concerned about this tremendous aggregation of economic power. And we're coming into the Gilded Age with a level of inequality like we have today. And Teddy Roosevelt and a number of others really championed this, and they passed a bill that prohibited corporations from making contributions to candidates. A few years later, a similar bill prohibited labor unions from making contributions to candidates. And we've had that for about a century at the federal level. During much of that time, elections were funded literally by the victors and the spoil system. Government employees were basically forced to pay for the candidates of their parties. And once those people won, those people would keep their jobs. It wasn't a good system either compared to what we have today. Political campaigns were totally different in that the ballots on which we voted were colored sheets of paper handed by a party to a voter on the way into the polling place. And so can you imagine like the clarity that everybody knew how you were voting based on the color of the ballot you turned in for the whole party's slate. So our political campaigns, while they may not have been dominated by corporate money like we're talking about now, they were dominated by a different sort of corruption. A corruption that had set in by virtue of a political system that did not protect the public interest, and it was really a spoil system of who won. So we had this complicated system, but it wasn't dominated by wealth, really in the 20th century. And it began to be. And how many of you were there to see Watergate unfold? We have a room full here of people who remember Watergate. The great scandal of Watergate was not just the wiretapping. It was also the fact that it was uncovered that Richard Nixon was receiving contributions from corporations, contrary to these laws that were not being enforced. So in the early 1970s, following the Watergate scandal, there was this huge public outcry for the need to deal with this corruption that was left in the wake of Richard Nixon. And that led to the passage of the Federal Election Campaign Act. So for those of you who were paying attention in the 70s, and this room of people were, this was a clean government law coming out of the Watergate scandal. But it had a number of provisions in it that were truly problematic. It limited what people could contribute to a candidate to such a low amount that it would be difficult for a candidate to raise money. And it made it very difficult for a challenger to take on an incumbent politician. It also made it illegal to spend money independently of the candidate. It had a lot of very strict rules that were genuinely a problem for freedom of speech. So the New York Civil Liberties Union and the National ACLU sued alongside Buckley, who was the plaintiff in the case, and that became the Buckley case in 1976. So remember that we had the scandal of Watergate, and then we had an overly restrictive law, and then we had a sweeping court decision. 40 years ago, long before Citizens United, the Supreme Court ruled that there can be no limit on what a person can spend independently of a candidate for or against that candidate. So when you hear people say we need to reverse Citizens United, they're actually not looking far back enough, because it was the Buckley decision, a precedent that is now 40 years old and quite firmly established, that prohibits limits on what wealthy people can spend for and against candidates. What the Koch brothers want to spend, if they want to spend with their friends $900 million in this election cycle, has nothing to do with Citizens United. It has everything to do with a precedent that is now 40 years old. If George Soros or Tom Steyer want to spend 50 or 100 million, it's not because Citizens United allows it. It's because the Buckley decision allows it from 40 years ago. So my point is that this is not as easy as reversing Citizens United, because the core issue of economic inequality that's presenting itself in our political campaigns is still being expressed through the power of wealthy individuals, billionaires, and multimillionaires. And it's not yet for-profit corporations that are establishing this level of political problems that we're seeing in campaign finance. So that took us through Buckley. And then we had another wave of scandal, the savings and loan scandal and the corruption that was surrounding that. And a number of reformers, John McCain, who was kind of tinged with the savings and loan scandal, Senator Feingold at the time from Wisconsin, came together and they passed a new bill, the next version, which we now know as McCain-Feingold. And that's the case that went up to the Supreme Court. Now, I was pretty upset by Citizens United also. I gave a fairly measured answer, but I was upset by it, just like most people in this room. And I went back and I read the decision. How many of you have read the Citizens United majority decision? One hand, two hands, three hands, four hands, four hands. When I read the decision, I was actually struck by how much of it I agreed with. And that has something to do with how restrictive the laws have been that these court decisions strike down. In McCain-Feingold, this campaign finance law, it literally says that if a corporation were to spend $1,000 in an independent expenditure for or against the candidate, that the person could be acting on behalf of the corporation, could be put in jail. So now raise your hand in this room of civil libertarians, in this room of people who fight to decriminalize drugs and reduce incarceration, if you believe that a person spending $1,000 on behalf of a corporation, buying a silly ad or a newspaper ad, ought to go to jail. Like, no hand just went up. And yet that is what the law was that went before the Supreme Court. And so that made it pretty easy for Justice Kennedy to pick an example like that in the law to strike down the whole law. And that's exactly what they did. So the Citizens United case then got decided. And what I want to just draw your attention to, this was one of my big takeaways from like actually reading, which I haven't done as much since high school as my mom would have wanted me to, is this cycle of scandal leading to very restrictive laws that then go to sweeping court decisions that strike everything down in their path. And as long as we stay in this cycle of scandal, overly restrictive laws, and sweeping court decisions, we're not going to get out of our current campaign finance system problems. When I go and speak to groups like Common Cause and these campaign reform crowd, I don't talk to them about the need to overturn Citizens United. I talk to them about the need that the next generation of campaign finance laws should not have jail as a penalty for people buying a few TV commercials. The next generation of campaign finance laws should not have outright bans on people being able to criticize Hillary Clinton in the 30 or 60 days before an election if she's the candidate. The laws themselves need to give more flexibility for freedom of speech and freedom of association in the period near elections. Because if the next set of laws comes back with felony convictions for political speech, I think the courts should strike them down. If the next set of laws come back with limits on contributions that are so low that it's very difficult to organize and fund a campaign, then I think the courts should strike them down. But that doesn't mean we have to live with the system we have. So let me take you into what is it that makes this all so difficult. Are you all following me? This is like a level seminar, right? This is like complicated. And then you have to actually stop and think about this because it's not as easy as it sounds. And I want to give you like the four, I have six, but for the purpose of time, I'm only going to give you the four big challenges. So the first is money and speech. Okay, who's heard the slogan, money is not speech? Okay, like, well, that's clearly true. Because like money is currency, money is either cash, securities, whatever. Money is clearly not speech. But money is essential to communication in a modern society. Can a newspaper function without money to print it? No. Can a nonprofit association like the NAACP or ACLU function without contributions and without expenditures? No. So money is essential to communication and to political campaigns. So how do you deal with restricting money when money is being used for the purpose of communicating political ideas? It's not that easy to say money is not speech. And then there's the problem of speech itself. How do we distinguish a person wanting to criticize a candidate from election-related expenditures? And that actually is really hard. So when Barack Obama is the president of the United States and he's up for re-election, and he's making hundreds of executive decisions and voting whether to sign or veto bills, and anyone wants to criticize the president during the 30 or 60 days before that election, is that campaign speech related to the election? Or is that just the job of criticizing the sitting commander-in-chief of the United States of America? So this is the first big bucket that's difficult. It's the relationship between money and speech and your ability to distinguish the different kinds of political speech from a political campaign itself. Okay, now I'm like really taking the wind out of everyone's sails. This is not fun. So let me go to the second one. The second big challenge is corporations and people. How many have heard the slogan that corporations are not people? Okay, that's like a pretty good sign. It's a decent bumper sticker. But it's actually not that easy when it comes to the law. I keep picking on the NAACP and the ACLU. We're both corporations. Your local solar roofing company is probably a corporation. Most of the associations that you see, labor unions, are corporations. And so are for-profit corporations. And so drawing the line between who can exercise which rights is not totally straightforward. How many of you believe that for the San Francisco Police Department or the FBI to walk in the door of the American Civil Liberties Union, to walk out with some of our files, that they should have a warrant? So what you all just said is that you believe that the ACLU, as a nonprofit corporation, is protected by the Fourth Amendment of the United States Constitution. How many of you believe that for the FBI to go into the headquarters of Chevron Corporation to walk out with documents, that they should require a warrant? It's like just about the same number of people. And that's because we believe pretty strongly that the Fourth Amendment's right to protection from an illegal search and seizure should protect not just us as individual human beings in our homes, but also when we've come together, whether it's for the ACLU as a nonprofit corporation or Chevron as a corporation. But does that mean that Chevron gets to vote in an election? Obviously not. But where do we draw that line between what Chevron can do and what Chevron can't do? Can Chevron spend money criticizing the decision of a president? I kind of think they should be able to. But does that mean Chevron can spend a lot of money on an independent expenditure for or against the candidate for president? My view is they shouldn't. But working through this is not as easy as it might seem. So is this like really frustrating now? I hope I'm frustrating you, because it is genuinely frustrating. Okay, let me take you to the third one. There's some people here from the Friends House. So I spoke recently at the Friends House, and I posed this question. Raise your hand if you're for the ability of the government to censor its critics. Okay, raise your hand if you're for censorship. Raise your hand if you're for the government being able to tell Marty McReynolds how much of his own money he can spend criticizing the government or people in that government. Raise your hand. Okay, we're getting there. Raise your hands if you're against Citizens United. So this is actually a genuine problem, because the law that Citizens United struck down limits how some people can spend money criticizing people who are in government or who want to be in government. We call that censorship, and let's be honest about it. You can rename censorship and call it campaign finance regulation, and that's fine too. But I think the point is that the line between censorship and regulation is not so comfortable. And that's where the question comes of what's the penalty? And if the penalty is jail time, I will fight to the death against that. But if the penalty are some other reasonable restraints, that if Marty's gone and broken some rules, and Marty's taken to counseling and explaining to Marty these were the rules and don't spend too much, I can live with that. But we have to face this question and figure out, how do we design something that provides tools for regulation, but without creating the room for abusive censorship? Power can be abused, and that is why the ACLU exists. If power was not ever abused, we wouldn't really have any reason to exist. But it's because campaign finance laws can be abused by those who are in power to limit the criticisms of those very people that we have to carefully look at it and what those tools are. So the next one is this difficult issue of disclosure. How many of you are against dark money being awash in our elections? Against dark money being awash in our elections? Okay, I am too. I really am. I really genuinely am. I'm working through this stuff. But the reason that there's dark money flowing through elections is because there are entities called non-profit corporations. And these entities, non-profit corporations, have the ability to have political speech. And these entities called non-profit corporations do not have to disclose our membership lists. Reverend Bird spoke about how it was controversial to be an ACLU member or an NAACP member. And there's a case about that. Back in the, I don't like to say the darkest days of the civil rights movement, because they were in fact like some of the most powerful days. But in the worst days of Jim Crow, the state of Alabama wanted to force the NAACP to disclose its membership lists. Can you imagine, in the age of lynchings and terror, what that would do to people whose names would be associated with NAACP? And the ACLU sued and went to court with NAACP to protect the rights of a nonprofit corporation to have the freedom of association without having to disclose all of our members. So when there are people who want to disclose all of this dark money, the problem is, how do you do that without forcing all nonprofit corporations from disclosing their entire membership lists? Unless you can draw a line between the different kinds of political speech, it's very hard to draw a line between which nonprofits have to disclose and which ones don't. So I'm taking you through all of that, not to say that this is impossible to solve. You know, for crying out loud, we've solved much tougher challenges than the ones I just described. But we can't figure out a solution to campaign finance that upholds freedom of speech and freedom of association unless we're willing to work through those difficult challenges. So then the question becomes, what can we do? And where do we go? A year ago, I went to the board of the ACLU Northern California, and we adopted a goal. And that goal was that this organization is going to be part of the solution for campaign finance reform. And one of the board members, she's like, well, but don't we need to know what the solution is before we can adopt a goal like that? And I'm like, you know, I don't know that I have to like come up with like a whole book of solutions just to commit that we'll be part of the solution. So let's commit ourselves right now that we will be part of the solution. And let's take the time to figure out what those solutions can be. So let me just share with you a couple of ideas that we're thinking about, and then I'll close. So the first is, do you remember I talked about how political parties used to print the ballots and they were color-coded? And so a person would literally walk into a polling booth with everybody watching them, knowing that they would have voted in the view of whoever had power over that voter. That's not a free vote. That's not a vote of conscience. That's a vote of coercion. That's a vote of power exercised over that person. It's kind of stunning, the idea that we would have let the parties print the ballots when the person walks in with a color-coded. It is kind of nuts, right? Yeah. And I think that's how we have to look at our current system of privately financed elections. When you think about it, in 30 or 50 years, let's look back on it and wonder, how did we leave it that this level of economic inequality could exercise so much power through our elections through a system of privately financed elections? So we will, at the ACLU of Northern California, adopt a pretty vigorous program to support public financing of elections. But even those get complicated. But I'm going to spare you those complications because that's just too much punishment for a nice Sunday afternoon. Well, can I give you one? Let me give you one complication on public finance. How many of you believe that the public financing should be equally available to all candidates? Okay, equally available. Everyone raise their hands. Okay. How many of you want the taxpayer dollars that could be going to your schools and fire department to be given equally to every random person who wants to run for office because there's now an equal amount of money available to them? It's like that's going to get a little nutty when some of those kind of candidates, you all know what I'm talking about. You might even be some of those candidates. But look, I look at the whole ballot, and I'm like, I don't want my money going to all these people. But there's some very nice ideas. The matching funds are a great model. In New York City, when a person makes a $20 contribution to a candidate, it's matched 5-to-1 by the public financing system. So it's a very nice way of aligning the public finance with the level of support the candidate's building, and it's equally available to all candidates. So there's some really nice solutions there. Second, and I'm going out a little bit on a limb, because I'm getting ahead of our board and what they've signed up for quite yet, but I feel pretty comfortable they'll be with me on this, is we have to roll back the amount of corporate power that Citizens United allowed. And there's a way to do it that I think doesn't mean that every nonprofit corporation loses its political rights. I think there's a way to do it. But here's the challenge. In California, there's all this uproar about Citizens United, right? Like a lot of uproar. Citizens United allows corporations to make independent expenditures for and against candidates. It does not allow direct contributions to candidates by corporations. Well, guess what? In the state of California, corporations have been, for I think a century, able to make direct contributions. So if I want to roll back the power of corporations, it's not as simple as just saying overturn Citizens United over there, because with or without Citizens United, we've had 100 years of corporate contributions to candidates in this state. So that's actually a pretty tough job to take that away. Can you imagine like trying to pull that away? Like which legislator will vote for that? And like which corporation will just roll over while Abdi Soltani tries to take away their corporate contributions to candidates? Like not that easy. So, but there's a way we got to pull that back somehow. And then the third one, and this is where I think our board is ready to go, is we can't just tackle Citizens United. We have to go back to Buckley. That's the case from 40 years ago that allowed the unlimited expenditures by wealthy individuals. No ACLU affiliate has ever gone there. And for us to go there, as an organization known for free speech, to stand on the side of setting some limits on what some people can spend out of their own pocket for and against candidates, that's when we cross that limb, when we go out on that limb, I have to make sure that we're on very firm footing. Because for the ACLU of Northern California to take that position, and then to advocate on that position, we will, like the barrage of people will say, like, ACLU has abandoned its free speech principles. It'll be like pretty rough. But I think we need to deal with that because this level of economic inequality cannot express itself in our political system as it does today. And I think that that's a challenge that's worthy of us. It's a challenge we have to take up, but it's a challenge we have to take up in a manner that's consistent with free speech principles and First Amendment principles. So let me just then close with a very simple concept, which is that the ACLU is about the freedom of speech and freedom of association. But we're also for equality. Equality as was expressed in the Declaration of Independence. Equality as was expressed in the movement in the battle against slavery. Equality as was expressed in the fight for women's suffrage. Equality as was expressed in the battle against Jim Crow. Equality as was expressed here in Sonoma County in the ability of workers to form unions and have a collective voice just as management has. So we've also been on the side of equality. And another civil liberties concern is representation. Freedom of speech is important, but so is representation. Representation as was in the Declaration of Independence. Government of, by, and for the people. Representation is why we fight for the right to vote. Why we fight for the freedom of speech is so that every person's views can be respected and heard in the society. And I don't think our current system of campaign finance allows for the best equal representation of all of our people. So I didn't come here with much worked out. This is a work in progress. We expect that by next year, 2017, we will be actively deploying some strategy to take up some piece of this question in some responsible way. So I really appreciate the chance to be here. This is one of my first times talking publicly about this project of thinking differently about campaign finance and figuring out what the solutions are. And I really welcome your feedback. My email address is available pretty freely, but I'll just tell you it's my first initial and my last name at aclunc.org. So if you have any question, any feedback, it really will help me as we refine these arguments and work out our way forward. So I really appreciate, wow, everyone really stuck with me. I've been looking around the room like, you're not that happy, no one looks happy. Things in your life are much more complicated. But we have to work, we have to walk through the difficult stuff to get out the other side, and that's the process we're in. Eventually I'll have like new slogans that will replace money is not speech, but for the time being I don't have slogans, I just have questions. I'll stop there, and I appreciate everyone being here, and I thank you for